the beginning of the hour, I mentioned that a juror in this case was dismissed. Well, we have some more information about it. This juror that was dismissed posted Monday night after being chosen for this case. Didn't mention anything about which case it was, but then he posted on Tuesday night after day one. The judge let the jurors have their phones briefly to make phone calls, but it looks like he did a social media post. So this juror has been dismissed off this case. An alternate has been brought in. And to help me talk about that factor, as well as everything we've heard in this case so far, I'm joined today by criminal defense attorney David Pietro. David, great to see you again.
Good morning. Thanks for having me.
Good morning. So I want to start. Let's start. Eric or Derek? Now, what does this mean? These are the words that apparently Jessica Chambers had uttered to first responders. Eric or Derek? Not Quentin Tellus. Case closed?
Well, I wouldn't say case closed, but all they're going to have is this excited utterance or this dying declaration that they're trying to get into evidence. But it's actually backfiring a little bit because now you have the Eric and the Derek. So they're really going to have to flush that out and make sure that the testimony comes out the way they want it to come out, because it could be a double-edged sword and could create doubt in the minds of the jurors.
Ironically, it's the prosecution who's putting on the case first, but that was a good day for the defense, if you ask me. I have so many different people saying Eric or Derek. Now, I want to unpack this a little bit. The jurors don't know this. They only see what's presented in the courtroom. I've had the opportunity to watch and read a little bit about what John Champion has said, the prosecutor, in anticipation of the trial. And he said that they investigated every single Eric or Derek in the community, everyone that could have been affiliated with the case, and none of them checked out. If you're the prosecution, do you have to put forth some sort of evidence that, look, we did a thorough investigation of Erics and Dereks, and if they do that, how do they put forward that in this case? How would you expect that testimony to go, or who would they bring forth to do that?
Yeah, I think that's reasonable, and I also think they should probably bring in family members and friends and ask her in social media, did she have any friends named Derek? Did she never know a Derek? So that'll eliminate known people in her life. And then as it relates to Dereks in the community, I think a reasonable search within a regional parameter to eliminate all Dereks will help draw the conclusion that it wasn't a Derek, that her mouth was burned, and it sounded like she was trying to say Eric and not Derek.
Let's talk about that, because what the prosecution is going to say is this girl suffered tremendously. Her injuries were so catastrophic that they damaged her vocal cords, her esophagus. She engulfed fire. So is it fair to say that what they may have heard as Eric and Derek, maybe she was in fact saying Quentin? Now, I'm assuming that we'll have medical experts come on to testify to that fact, that maybe if vocal cords are damaged in such a way that what you hear is not actually what someone meant to say. But I'd like your thoughts on that.
Yeah, I just hope the prosecution is not basing their entire case on this, because by the preponderance of the evidence, she probably said Eric. Beyond a reasonable doubt, that's the question. Can they prove it and eliminate the Derek issue? So it's really, there needs to be other circumstantial evidence they need to draw on this case other than an excited utterance.
And David, there's also been discussion, if you read the medical boards about this, that when a car burns, there's gases that are released from the plastic, and it can alter someone's state of mind. In fact, and don't quote me here, but I believe that Jessica Chambers at one point, when asked her name, she was a bit confused as to her own name. So again, it adds to that fact that if the defense, I think the defense is really relying on this Eric or Derek. When you heard their opening statement, it was very short compared to the prosecution, and they said, you heard Eric or Derek. Now, if they're basing it just on that, when it's possible her vocal cords were damaged, it's possible she wasn't in the right state of mind. Oh, and let's not forget, this poor girl was burned alive. Is it fair to say that she was in the right state to make an accurate statement? I'm not sure.
Right, and what did she say Eric and Derek in conjunction with? Maybe she wanted to see him. I mean, or presumably asked, "Who did this to you?" So it's really how it comes out and how the context of everything. And you're right, the mental state is going to be a big issue, because not only being traumatized in a disgusting way, in a horrible, heinous way, and then also all the other things that go into this kind of trauma as it relates to the right state of mind.
Well, it's interesting also, let me just add that I believe some of them asked Eric, okay, they would ask her, what's his last name? And either she said she didn't know or it was Eric. So It's possible, I mean, it is possible that the attacker wasn't Eric, and maybe she didn't know who he was so well. Maybe she knew his name was Eric, but who knows what really happened. I want to talk about what the prosecution's case is. This is day 3 in the trial, and we saw in the opening statements from the prosecution the roadmap that they're going to go for it, and what it seems like they're going to say is cell phone evidence tying Quentin Tellus to Jessica Chambers around the time of the incident, and the fact that he lied and was not totally truthful with investigators, and he had a gas canister in his shed, trying to map out what he did. But this is a circumstantial evidence case. You don't have any eyewitnesses. You don't have that smoking gun. If you follow the roadmap that the prosecution has laid forth, do you think that could be enough to convict this guy?
They're going to have to put him at the scene of the crime, either directly or indirectly. So I think the cell phone evidence could be good. Hopefully they have the GPS where they can ping the locations of where he was, and he was within that area at the time that they believe the crime occurred. They need to put all those little pieces together so that the jury can feel confident that he was the actual one, the one that actually committed the crime.
And unlike other cases, this really is a minute-by-minute thing, because there was an hour, what we're talking about, when we could track her movements from a nearby gas station. And tell our viewers something else. This gas station, if I'm correct, is right by his house, right by Quentin Tellus's house, or where he was staying, and he had a gas canister in his shed. The idea that all of this is within the same community, if you heard what the prosecutor, John Champion, said, he said that they can pinpoint the fact that someone left Quentin Tellus's house at a certain point, went in the direction of where this scene took place. Again, it's a minute-by-minute thing. The defense is saying, well, Quentin Tellus, he wasn't anywhere near this crime scene. He was going to get a prepaid debit card. Now, the prosecution's saying he got the debit card after. So it's going to be, I think, so important to map out minute by minute where he was, and at the end of the day, I believe the jury is going to have to say, okay, make sense of it. What happened by what minute, what happened by what minute, and that's not an easy task, but I would like what you think about that, where you have to map a case out so closely in time. It's different than other cases, am I right?
Definitely. This is, now with technology and everything else, jurors demand more, and especially in a case like this, where they're not, there's no confession they intend to bring in and things like that. They really have to pinpoint that it was him that was at that place at that time, and it could have been nobody else, logically or reasonably, to commit this crime. Yeah,
the town of Cortland, where this happened, is 1 square mile. The population is about 500 people. I mean, you're seeing this small kind of community. There is one other part of the prosecution area that I want to talk about. It's the DNA. Quentin Tellus's DNA was found on her keys. Okay. Now again, we know that they were in a relationship. We knew that they knew each other. But her keys were found by a passerby in a ditch. Doesn't this not look well for Quentin Tellus?
It doesn't, but he wasn't a stranger, so there can be a million explanations as to why his DNA was on her keys. Maybe he drove her car before. It's good that the prosecution does it, but a good defense attorney can poke at it. And unless they can determine whether it's old DNA, new DNA, and things like that, just DNA alone is not going to be enough.
David, I don't know if you heard at the beginning, but a juror was dismissed for posting Facebook posts about his appearance at his serving on jury duty. Didn't talk really necessarily about the case, but how frustrating is this? How frustrating is this to happen when you begin a case, you've selected a jury? Didn't they know better?
Yeah, and those standard jury instructions go over and over and over about you can't talk about the case, you can't talk about the case. And to do this and post on social media, and it's a death penalty case, which now raises the scrutiny level a lot higher than a normal homicide case. So everything's going to be scrutinized after the fact. So this gentleman could have really tainted this entire trial process.
So irresponsible with so much at stake. Luckily, we do have alternates. And that's why we have it for this very reason. You would imagine that they wouldn't post, or that's the problem of social media, I guess. That's the problem. He was supposed to make a phone call, and that happened.
Correct.
Not easy. But speaking of the jury, the jury is going on a site view today. So they're going to visit the crime scene. They're going to see the M&M shop where and by the way, it's not where they actually serve M&Ms. It's a gas station. That's where Jessica Chambers was last seen on videotape. How important is a site visit? How important is it for a case like this? Why do we need it?
Well, one, the jurors are not from that area, so they brought them in 200 miles away. So they need to put place and time and context into the crime scene, and they need to be able to visualize it. We live in a visual society where everybody wants to visualize everything anyway. So it's important to just put all the pieces into the mind, into the vision, so they can map it out in their mind exactly where the crime occurred and how it occurred.
David, you know what's interesting? I was listening to the prosecution's opening, and the very first thing is they're not allowed to have, when they go into the deliberations later on, they're not allowed to see the transcript of prior testimony. This is a lot of information for a juror to handle. Can you just explain to us a little bit, when you're handling a trial, what are jurors allowed to do during the trial? They're supposed to obviously pay attention. What's the limit of them being able to take notes, trying to remember all of these details? At the site visit, they probably can't take pictures, but what can they have, what can't they have when they eventually go into deliberations, when, again, this is a minute-by-minute case. There's so many facts. I know I have to keep reviewing them. What are they able to do here?
So I know in Florida here, we allow jurors to take notes, and there's a jury instruction about how they can use their notes, but they shouldn't rely on just their notes as it relates to how the evidence comes out. I know they can have readbacks too, where the court reporter will read back the testimony of any witness they'd asked to hear the testimony again. That's a very boring way to re-listen to testimony, but there might be something in that testimony that they want to hear. Unfortunately, they usually have to hear the whole thing. They can't just hear bits and pieces of it. So they would have to listen to it. And if there's certain things that they're deliberating and then they want to refresh their minds on a certain part of the testimony, then they can have a readback normally.
Let me give you an example of a piece of detail that they should take a note of. There was a discussion yesterday on the stand about there were lighters, cigarettes, things at the crime scene that investigators initially ignored. They said, oh, there was rust on that cigarette lighter. You could tell it wasn't working, it was old. But the discussion becomes, those are key pieces of evidence. You didn't collect them. You didn't think they were relevant to the investigation. That's a botched investigation. You would think that goes towards it. What are your thoughts on making presumptions or saying that, oh, the firefighter put out that cigarette, or those cigarette lighters that you see on the floor, they're old, they could not have been used. The idea that the defense could use this, that this was a botched investigation.
Correct. They're always going to attack the investigation if they can. Spoliation of evidence, where they basically either destroy evidence or don't collect evidence, can be used as to create doubt in a case. So if it's that immaterial, they should have just inventoried it, took it, and disregarded, but always had it in their possession so that they could say that they took everything they could in the area and inventoried it.
Well, I would imagine the defense is going to keep doing that whenever investigators come on the stand, that they could have investigated this person, but they didn't. Again, at the beginning of our discussion, we talked about Eric and Derek's. If I was the defense, go right after, how come you didn't investigate this Eric? How come you didn't investigate this Eric? Or did you not check this part about Eric? You know, it's so easy to say that somebody checks out. It's so easy to say, we checked that person's story out, didn't work. But why? I would
go on the sex offender list that they probably have in Mississippi and go through every sex offender that's registered that's an Eric or a Derek, and just say, did you investigate this person, this person, this person? That could be statewide, maybe even Alabama and Louisiana area, depending on proximity, and really go through the list.
So again, I don't know how many Erics or Dereks they investigated, but if you were defense counsel here, could an option be you go on this, you have the lead investigator on the stand, and you say, okay, and you start listing name by name by name, and you say, did you investigate this person? Yes. Why did it not check out? Would you just go through the entire list? Let's say there's 100, 200 people. Would you do that?
Yeah, I don't know if I'd do all of them, but I pick out some really good ones, and
Yeah.
I'd really show how the Eric and Derek investigation probably wasn't as thorough as anybody could actually make it.
And let me tell you something. I think everybody hopes that all those Erics and Dereks didn't check out. You don't want a guy on the stand, you don't want a guy, who's on trial, who doesn't deserve to be on trial. You want the right guy, especially in this kind of brutal case. So I hope we see testimony like that. Talking about Quentin Tellus, this guy, if convicted, faces life without the possibility of parole, but he was eligible for the death penalty, but the prosecutor's office chose not to seek the death penalty. I've asked a few different people about this. Why do you think they didn't choose to go for the death penalty in this case?
Well, it raises a level of scrutiny. So, like in Florida, when it's a death penalty case, there's a two phases of the case. There's the conviction part, and then there's the actual death penalty phase. And you get the expense is tremendous. You get the defendant will have at least two lawyers. And then there's automatic review, usually by a higher court. In Florida, it goes directly to our Supreme Court. And they're just cases that are really scrutinized at a different level. And if your evidence is a little attenuated, maybe, to get a conviction and to avoid a possible reversal on technicalities, they decided that it was the best move to put them in prison for life.
Does the fact that if a jury knows they're on a death penalty case, you're concerned about that affecting their decision?
Well, see, that's also a double-edged sword, because in most case law around the country, when you pick a death-qualified jury, as they call it, every person on that jury will have to say that they would be able to follow the law and provide a death sentence. So usually you're getting more conservative jurors. So for us here in South Florida, where we have a lot of maybe more liberal-leaning people, and you try to weed out and get more conservative folks that can, and it kind of helps you pick a jury. Now, Mississippi's probably everybody's sort of conservative there, so maybe they don't have that consideration. But these are all strategy and consideration and things you need to consider when you're deciding how you're going to proceed on a case like this.
What about the morality punishment argument, in the sense that serving life in prison without the possibility of parole, is that a worse punishment than the death penalty?
That's the debate we're going to have in our society about the death penalty, and it's becoming, as crime goes down, you'll see the studies show that the belief that the death penalty is effective goes down. As crime goes up, people start to believe in the death penalty more. This case, to burn somebody alive, it's on the level of a death penalty case. It's pretty disgusting. It's not a drug deal gone bad, or somebody in a heat of passion killed somebody. It's just pretty disgusting stuff.
Yeah, it's horrible. It's really horrible to watch. Remember, I want to remind our viewers that this is a little bit different than a first-degree murder charge, because the prosecution doesn't have to show intent. What they basically said, this is a capital murder crime, in the sense that this is a guy who, if you believe what they're saying, who committed third-degree arson, and while committing that felony, the arson, it resulted in the death of Jessica Chambers. He doesn't have to intend for her to die, but her death resulted. How does the fact that they don't have to show that intent play into this case?
Yeah, so it's what we call that in Florida is felony murder. So they're just trying to prove the arson. And if they can prove the arson and then somebody actually died because of the arson, they don't need to prove that the person committed the arson with the intent to kill somebody. So I guess the way the evidence is coming out, they probably have an easier scenario to prove arson over a homicide.
Yeah, definitely an easier case, but it's a good thing that we have that kind of law in this case, because in this jurisdiction and in the country in general. Because how many times do we know somebody commits a robbery, in the commission of that robbery, someone gets killed, not from them, but maybe someone took out a gun to try to protect the bank, and they shoot somebody. They could be, the perpetrators could be responsible. That's the reason why we have this law. I do want to talk, before we go to our live feed, hopefully in Chambers, there's this guy, Quentin Tellus, doesn't have the best past, and he's not in a great situation right now. What am I talking about? Well, he's already in jail for the unauthorized use of a debit card that belonged to a 34-year-old Taiwanese exchange student, there you go, right there, who was stabbed over 30 times. Now, he wasn't initially implicated in that crime, but after a further review of the evidence, he was charged in connection with that crime. He will be on trial for that murder. How does that evidence come into this case, if at all? Again, it's about his prior bad acts. It's about his prior history. You have to be very careful about it, but in what way could you bring that into this case for the jurors to hear?
Let's hope his attorneys are smart enough that he is not put on the stand, because if he goes on the stand, his convictions, not what he was convicted for, but his past could come out if he has past felony convictions. It's hard to tie the two cases together, and it might be that they're trying this case first because they want to use this case as a predicate for the death penalty in the second case. So there might be strategy as it relates to that, because in a death penalty phase, you can bring out the mitigating, aggravating factors in a person's past criminal acts are part of an aggravating factor that can be brought out.
Interesting. So if he's convicted here, goes on trial for the stabbing, found guilty of the stabbing, and they elect to go for the death penalty there, then it's in fact he might face the death penalty. I am curious, could you use his, that he's at least on trial or will be on trial for the stabbing, could you use that in a way to say this is a pattern? This is a pattern of a guy that's committed violent acts against women?
Tough. I mean, we have exceptions for rape and molestation as it relates to what they call 404 2B evidence, that you're acting in conformity with things that are within your personality or things that you've known to do. To get that other stabbing involved in that case into this case is going to be pretty hard, I think.
Yeah, I agree. We'll have to see how they do it, because he really does have a very interesting record. I mean, again, he is in prison now, faces a 10-year sentence for the unauthorized use of that card. I do want to talk a little bit about the actual crime here, the burning. What I've seen people say is that burning someone is a personal crime, in the sense that you usually see it where two people know each other. You don't see it so much with strangers. I want to know what your thoughts on that are. I wonder if we'll see testimony from certain experts testifying to the nature of burning crimes. What do you make of that?
I think so. I think that's a good point. Most people either stab or shoot or strangle or a person when they commit a homicide. To burn someone that is on a whole nother level. I mean, you have to have really a depraved mind, and really you could see that's not something you do to somebody that you want to rob or whatever. It's something that you want to really, it's from a depraved part of your person. So there might be testimony as to, burning versus other ways to commit a homicide. So I think you raise a good point. Yeah,
the interesting part is because they were in a relationship, or for the 2 weeks that they knew each other, they apparently knew each other, were in some sort of relationship. What is also interesting, and I should note, is that John Champion, the prosecutor, mentioned it's his theory that Quentin Tellus suffocated her and then burned her. Now the idea is, did he think that she was dead or not? But he still tried to, maybe he tried to suffocate her, thought that she was dead or thought that she was knocked out, and tried to get rid of the evidence. Now, even so, if that's the case, it doesn't matter, he'd still be convicted. But it's just that we're trying to make sense of such a gruesome crime, such a gruesome way, and this poor young girl, she survived for at least a short period of time from being burned alive, and the excruciating pain that she was in. You just have to try to make some sort of sense for it. And the jurors are listening to this, and they're hearing this. How much does the gruesome nature of this crime affect the jurors in rendering a verdict here?
Yeah, it goes to whether they want somebody like this back out in the community, because this is really a heinous level of crime. So the defense's job is to sort of admit that the crime was heinous, but that it tried to, point to the lack of evidence as it relates to their client being the person that did it. So if I were the defense, I would concede this is a heinous crime and try to walk around that fine line.
From what you've seen so far, do you think that this is, again, the third day? Just to provide an overview, what else will the prosecution need to do to really, really hammer it home for the jury, and really hammer it home that it was, in fact, Quentin Tellus and not an Eric or Derek who did this?
It's a timeline. I think they need to establish that there was no other person that was able to commit the crime based upon a timeline. This is the time approximately that the crime occurred. This is where he was in the same location, and really point that there's no other logical person that could have committed this crime. So they're really going to have to button down the minutes pretty tight to show that it was him.
And the defense, they just have to keep attacking the investigators and really try to bring up that Eric and Derek, right?
All day long. That's what they have. And don't put their client on the stand, because he's probably fold in a second.
I don't imagine that they will bring him on, but we've seen stranger things happen. David, thank you so much for joining us today. Really appreciate your insight into this, and we'll make sure to have you on to talk more about this case as well as other ones as we go forward on the Law News Network.
Great, I appreciate it. Thanks for having me.
Thank you.
Bye now.
Bye-bye. So we are expecting to have live coverage soon in Jessica Chambers. Again, this is the third day of that trial. This is the trial of Quentin Tellus, who has been charged in a capital murder case against, I can't even